department presents that long list of case plan, we barely have time to even look at it. We want to have the client look at it, sign it, and then off we go. But that should really, really change. So hopefully this presentation today will really guide us as to the new changes in the law that will help us navigate one of the most trying moments for our clients. It's not uncommon for a client to look at a case plan and believe, you know what, I'll be able to do this. And they give us that assurance. I'll do this, I'll do this. But down the line, you find out that the client is in partial compliance because the client agreed to take on more than what she could handle. So we have to be very careful going forward, and we'll now start with the presentation. So basically, we have some new attorneys here. So I will do some intro before I get into the main things that are beneficial to the new attorneys and also to the much more experienced ones. So not every party in a dependency proceeding is entitled to reunification services. We all know that. Because sometimes the bypass may apply, sometimes the client tells you, I don't want it, and they want to waive reunification services. But for the most part, we have presumed fathers, we could have two presumed fathers, we could have presumed mothers as well, and biological mothers, and we have legal guardians. All of them are by law entitled to reunification services. The only person that the court has discretion to grant reunification services will be the biological parent, and the law prescribes the requirement for that if it would be to the benefit of the child. So the court has discretion to do that. DNA parents qualify as bio, and for the most part, the court will give them that opportunity to have reunification services and quite possibly elevate them at some point to presumed status. Alleged fathers are not entitled to reunification services. I put in the last part, to whom does the no reunification bypass apply? The provisions are very common. The 361.5B provisions, 1 to 17, are the provisions that prescribe that. So if your client falls into that category, is a different training, is a different requirement. But reunification services could be denied your client if they fall into that category. The court's powers to grant, to order a case plan. Usually there's this fundamental misconception we have that the court has almost unlimited powers to order a case plan. But that's not necessarily correct. And also the misconception that the court has to basically go with the department's suggested case plan. And the experience has been that the court doesn't really do its own due diligence as required by law, and we're going to get into that as well. So in some cases, so the foundation of this training is that I used case law to explain the actual law itself. So you're going to see more of case law here, because sometimes the judges will ask you what's your authority for a proposition that you presented to the court or you offered to the court, and what they're expecting is to offer case law, not necessarily the statute, which in my opinion is sometimes wrong too, because authority could stem from the clear wording of the statute. So in the first case that I have here in Region B, the mother had serious mental health problems, would AWOL from mental health facility, would not cooperate with any agency that was willing to provide services. So the court in this opinion felt, based on this mother's history, that the prospects for a successful case plan was bleak. So the court chose not to order reunification services for the mother, which basically is against the law. So the other case I have here is in Benedict C, where the court basically did not order a case plan that encouraged mother. You know how the bench officers encourage you? I want you to do well. I want you to get into parenting class. I want you to get your life together. I want you to do X, Y, and Z. So that's basically what the court did for the mother without actually articulating a very clear roadmap for the mother to engage in order to reunite with the child. So, but I think that problem has been solved the way we operate today, because we have clearly written case plans which the clients have to look at and see whether it's appropriate and sign it. But during the development of reunification process, the courts were not properly guided, so they made a lot of mistakes that they've improved from that period. With respect to the court's discretion to grant reunification services, it's somewhat broad in some respects. So the next case I have here is in Jose M. In this particular case, the child and the mother, a teenager, they had conflicts in their relationship for the most part. And the mother was not able to really control the behavior of this child. So they were having disagreements. Even the people that worked in the house with them, helping them in home services, observed the tension in the home. But mother preferred a 301 contract kind of, but the court said, you know what, I'm going to order a case plan for you and the child because of the tension in the house. So that really like shows how broad the authority of the court, the kind of powers the court has when it envisions that going by work, a 301 contract may not really serve the interest of this family. So the court would order a case plan. The next case is Eric B. So in this particular case, it has a religious bent to it, where the family preferred to use Christian scientist-approved treatment for their child, but their child had life-threatening illness. I think it was leukemia. And the medical experts preferred the orthodox, traditional hospital treatment. So the court, while appreciating the rights of the parents to choose the proper treatment for their child, felt it had to come in order to save the life of this child. So the court actually went forward with a more orthodox treatment for the child. So the case that I think is very important, which I'm going to discuss down the road, is the case of Henry JP, where the court actually did not have unfettered powers to develop a case plan. The court has to develop a case plan within some limitations, within some parameters. And that is what is discussed in the case of JP, where we're going to get to that. So there are some provisions in the code section that I don't think we tap enough into. And one of them is that the case plan has to be reasonable and designed to eliminate the conditions that led to the court's filing of the pendency petition. So the case on point there that I believe will be helpful is the case of Daniel B. The point I was able to isolate there is that the court can order a client into an open-ended program, like a domestic violence program, without stating that it's a 52-week DV or is it 26-week DV. But for the most part, we as attorneys want some clarity, so we can come back in 6 months and say, my client has done 26 sessions out of 26 or done 42 out of 52. But sometimes in practice, that may work against our client, in the sense that if the client's goals are clearly set out, what they're supposed to meet as their goal in the program, and the client could meet that goal in a 12-week domestic violence program, or in a 16-week or 18-week domestic violence program. Once that goal is met, there's actually no need for the client to continue with respect to attending the rest of the, or engaging in a 26-week program. So I think we may be making a mistake in insisting that there's some clarity as to the number of sessions to attend. Do you have any questions?
I do. With regards to the case plan, I could be loud. It's for singing. Is it working? Yeah. With regards to the case plan, must be reasonable and designed to eliminate the conditions that led to the court's finding of dependency. One thing I'm finding is often an issue, especially in my department, is let's say a case comes in for domestic violence, and for example, dad had drug use or abuse like 6 or 7 years ago, prior to the filing of the petition. As part of the case plan, one of the requirements our judge normally makes is drug testing for the father, or even perhaps a substance abuse program. Now, it's not a current allegation that's pled, it's not something that's sustained, drug abuse is not a current, there's no like concrete evidence that the father is currently using, but nevertheless, because it was something that was brought up 6, 7 years ago, sometimes even more, it ends up on the case plan. How would you recommend going about that? Is that a reasonable case plan? Is that narrowly tailored?
No, it's not. Because there's a case that we're going to discuss, I think it's in the Sage C, where basically the unsworn statement from the other parent that found out has a drug history from sometime in the past was held not to be compelling for the court to order father to do drug testing. So the only problem is that we may have a scenario where we went into a negotiation with the department to get what we thought was a good language, and probably we have also a homo parent or potentially to be ordered by the court. So we tend to overlook some of those other things. The court may say, well, you're getting the child home and you have the language you want. You know, why are you opposed to testing a few times as part of the package? And then if you present that to your client, more likely than not, your client would say, well, I'll do it, I just want my kids home. So, but this provision, the importance of this provision, and we're going to discuss that in a little more detail, is with respect to incarcerated parents and deported parents. That's where the reasonable part comes in, because the case plan to be developed for such parents are completely different. And that's why where the court should weigh in, find out what barriers those incarcerated parents have, what barriers those deported parents have to accessing those services, and actually craft a case plan that addresses those barriers.
So can I follow up? Do I need that? Okay, so if one of the barriers is that the in-custody parent has, I don't know what they're called, like they're in a security like clearance or not in a security clearance, they can't access any programs, but the case plan is ordered nevertheless.
No, it shouldn't be, because 361.5 E1 subsection II basically says that the court may order a client into services provided those services are accessible, that the client has access to. Whether the fact that the court cannot do that still affects the client's ability to reunify with the child is another question. But I think that question is addressed in 361.5 E, 361.5(1) subsection E, basically alluding to deported parents, but I think it can apply to incarcerated parents, where if the services are not available in the place where the parent is deported, they have to be given access to an alternative means to comply with the case plan. So if your client is incarcerated where the services are not available, and the department does not explore an alternative means to comply with the substance of the case plan, then that is no problem. And another fundamental error I think the court makes is that the case plan by law has to be prepared and delivered to the court at most by the dispositional hearing. So the department has 60 days to do that. That's 16501.1, subsection 2. They have the window. But the department doesn't use that window as they should under the law. The department should use that window to determine the circumstances of each family, because the law says that the case plan has to articulate the circumstances of this family with the goal of helping them eliminate the problem. So the circumstance could be that the parent is in jail. So the department cannot recommend a program for a parent that is suitable for a parent that is not incarcerated when at the time the department was developing the case plan, they knew that the parent was incarcerated. So that is not a narrowly tailored case plan. It's a case plan that is designed to basically fail, as the court in Rejefi said, that is a trap for the parent. So if the case plan does not consider the status of the parent coming into the dispositional hearing, then it's not adequate, because your client will be signing off for something that you come back at the 2-1E, the client hasn't even started because it's not accessible. And also the department, any report that does not have the department contact the place of incarceration to determine what is available before developing a case plan or suggesting a case plan to the court is not reasonable, and it's not narrowly tailored. So there are some other cases where kind of confirm the legal principle that it has to fit the circumstances of each family. So the circumstance includes whether they are deported or whether they are incarcerated in developing the case plan. So the case of D is a case in point where in fact, in this case, the court did not even order a case plan for the father. It was merely a suggestion by the social worker that father would do well to get into a parenting class. So ultimately, the Court of Appeal found that no case plan was developed for the father, and is a reversible error. So the case of Edward C is slightly different, where the case plan was not articulated for the father, but because the father had had 2 prior runs with the court system involving physical discipline of the child. So when the court spoke of expectations that they wanted the father to meet, the Court of Appeal felt, well, based on father's experience with the court system and his continued use of physical discipline, that the father actually got a picture of what he was required to do. So, but it was a very thin line, and I think the decision was made based on the fact that the father's conduct towards the female child was egregious. The physical discipline was rather extreme, so I think that's why what the Court of Appeal was persuaded by. So the department takes on a primary role. We have a scenario where the department believes that they're the ones ordering a case plan for the parents, but no, it's not. The department just develops a suggested case plan, and it's the court that orders that. So, yeah, microphone. Sue? Yeah.
I had a client who was a prison guard, and he was beside himself at the prospect of being in a 52-week domestic violence program with many of his ex-offenders. And I was very successful arguing to Commissioner Padilla that an individual counseling program was the only safe alternative and was narrowly tailored. But I could easily see myself being unsuccessful in 25 other courtrooms. Any suggestions?
The main thing is that sometimes you speak to the judge that is right before you, or sometimes you speak to the Court of Appeal. So if you make the proper record, which will require your client testifying as to what his concerns are and why he believes individual counseling will give him the environment where he would actually embrace the topic being discussed and then help him alleviate the problem that brought him before the court, I think you would have made a very good record for the Court of Appeal to consider. What they are looking for actually is there a program that would address this problem? One program will be sufficient, not a multitude of programs like we have. Some of them are mere duplications of the other. So, but if you don't set that record properly, then you may not prevail on our appeal, obviously. So sometimes, I put this case here because it's kind of an obscure case. Sometimes we want the in-real where the court ordered a parent into a residential drug treatment program. Because sometimes when we are arguing a case or trying to settle a case or accepting language, we have to be aware of the enormity of what we are accepting. I know there's this concept that language doesn't matter, it's the disposition that matters. But the court could use the language that the court just sustained in order to compel your client to go into a residential drug treatment program, which you and your client never envisioned. So we have to be very careful working a case from beginning to the end.
Is it true? Oh, sorry. Is this okay? Okay. So I used to be in 421, and Padilla would always say that it's actually illegal to have a parent enter a program, that the courts, the dependency courts cannot order inpatient drug and alcohol, but only outpatient. Is that actually accurate? Because she constantly, which is great, I don't have a problem with that, but she is much under the impression that a judge can't actually order inpatient.
Well, which is good for our client, but
Right.
basically what DOD does is says, this is the program I believe that would eliminate the problem that is before me. So whether you go into the program or not is entirely up to you. So Padilla is right in a way that you cannot force this mother, like legally by force, but the court believes this is the only program that will eliminate the problem. So it's one of those broader powers the court has. To challenge that, you have to make sure that you build your case properly to make sure that if you file an appeal on that order, that you will prevail. But if not, the court, yes, can ask you that this is the case plan that will be sufficient. Whether you do it or not is entirely up to you. So in 6 months' time, they will determine what you decided to do. So this is almost a case on point where Nolan W, where the court ordered mother to enroll in a drug treatment program. The mother, on the penalty that if she doesn't, the court would impose jail time. So mother did not, the court ordered mother to go to jail for 300 days. The court of appeal said no. Now you can order the case plan, but you cannot infringe on somebody's liberty because they chose not to comply. What you need to do is to make your proper findings when you come back for the review hearing.
Can the court impose any sanction?
Yeah, they can keep it.
They can.
They can keep your kids.
Yeah.
Well, I mean, besides that.
No. So the case plan usually, we all know that it contains provisions for visits. So there are some situations where the court may not order visits. So I have a case in the Daniel CH, but there are some other instances where the court may not order visits. There are several cases on that in Loop L, in CC, and in TM. But I think the legal standard now is if the emotion, by clear and convincing evidence, that the emotional harm to the child exists or the physical harm to the child exists, and those findings are made by the required legal standard, the court could go ahead and do it. But for the most part, the court will order visits for our clients. So this is a very important case. For this purpose of this MCLE, the AG and JP are probably two of the most important cases that we could expand on, not only from a practical perspective, but also from an academic perspective, because it has a lot of materials that we underutilize, especially with clients that are incarcerated or otherwise deported. So in this particular case, this father was deported to Mexico. He indicated that he was able to visit at the border in Tijuana. So the expectation was that the department would arrange visits between him and his children at the border, and also refer him to services through DIF in Mexico. The department's arrangement for the visits were really unfortunate. They hardly did anything. With respect to referral for services in Mexico, the department essentially relied on DIF. So when they found out that DIF wasn't particularly helpful, the department did basically nothing else to assist this father. So though this case was a 2-1E reasonable services issue, but I can see how if we had used the proper provisions under 361.5E1 and the subsequent provisions, where we could have made sure that the court, knowing that the father was deported, would have ordered more clear case plan for the father and ways to make sure that he's able to comply, and if there are barriers to his compliance, specific orders how to eliminate those barriers. So, but I think that case should be read and then expanded on. Reunification services must be appropriate for each family based on the unique facts of this family. I restate that because the case of the MCLE, which is an important case because it deals with what we usually have in a 387 petition. But in this case, it's kind of unique. There's a male child and 2 female kids. The male child, physical abuse by the mother, was removed and subsequently returned. The female kids were not removed, so remained family maintenance with the mother. But at some point, while the children were all with the mother, there was a sexual abuse allegation against the mother's significant other. The mother was a failure to protect. 387 was filed, was sustained, but the court did not feel that it needed to order a separate case plan for mother to address sex abuse awareness. So the court felt, well, for reasons that are difficult to understand, the court did not order a case plan for those issues. So the Court of Appeal said, no, you cannot do that. Those are issues that did not arise when you made the initial order. But if the 387 was a continuum, or a continuation of the old problem, like the 387 says that the existing case plan was not sufficient to ensure the safety of the children. That is not what happened in MCLE. It was a completely different scenario. So the court was supposed to order a separate case plan for the mother, considering whatever the time frame was with respect to Michael. So if she had run out of time for Michael, that would apply. But if for the other children, she wasn't out of time at all. So does the court have limits to its discretion? Yes, the court cannot order a case plan that is designed to fail. And I will now discuss the case of the JP. This is a father that spoke only 2 Burmese languages. One is traditional Burmese, the other one is a dialect called Karen. So wasn't able to speak any other language. So the department knew when they would use that 60-day window to work with the family and develop a case plan, they knew that there was no service for this father in the language that he would understand. So the court was aware of that. So the allegation against him was substance use, so he couldn't get into a program, substance abuse program that understood the language. Individual counseling was not explored by the department. The only option for him was testing, which he did test. So the court knew when they came to the dispositional hearing that there were no services for him. So the court still ordered him to a full drug alcohol treatment program without actually stating how the court intended those services to be complied with. So basically, when you have a client that speaks Quiche or some of those unique dialects, it's not uncommon for them to claim some knowledge of Spanish. But you have to be very, very careful when you give the impression to the court that my client understands Spanish, because it may come back to bite you. So it's better to stick to the language that they feel comfortable with. Not only because they may not understand everything that is done in the services, the program, when Spanish is used, and they are better able to understand, get insight if their traditional language is used. And above all, we use the interpreters in court. So that shows that there's a need for an interpreter to be involved. So in this particular case, the Court of Appeal felt, that this is where the court should have done what the court is tasked with doing, which is crafting a case plan, not relying on the department. So in crafting a case plan, the court has to consider the barriers now. So the barrier now is the language difficulty. But Judge Arakaki basically ordered that the department to refer father to drug treatment program and language assistance. That was all. It wasn't enough. So the Court of Appeal expected the judge to say the department to order father into services with the assistance of a translator, or alternatively, determine whether a different kind of program would be appropriate for the father, where if it was, I'll give an example like a domestic violence program. If there's no Burmese language domestic violence program, whether individual counseling with a counselor that spoke Burmese would be appropriate to satisfy that. Or whether in this particular case AA was ordered for the father, whether there's a Burmese AA graduate that could mentor the father to help father satisfy that requirement. So the department needed to do much more for the father, which they do not do. So that brings me to the normal case plan that we often see. Individual counseling to address case issue. So this kind of case plan has a lot of problems. Because one, it doesn't tell the client the goal. So they usually will call you. My counselor wants to know what my goal is. It doesn't. Then secondly, your client coming back at the 2-1E to testify as to what they've learned doesn't narrow the issue. So that presents a problem. So we usually would think, well, oh, they left it, to address case issue that is beneficial to us. It is not beneficial at all. That's what I found out. And also, it doesn't address any of the barriers as well, if they exist. Like if a client is incarcerated, it doesn't address alternative services for the father. It doesn't address whether they explored possible other means of complying with the case plan. So I think we should dispense with an order that says individual counseling to address case issues. Another area that I think we should push back on is what amounts to duplication of case plan, like anger management, domestic violence, and then individual counseling, and then the ever-present parenting. So you put all that together, you look at the case plan, you wonder, well, put yourself in the shoes of this client. Can I do this? If something like this were to happen to me, can I do this? It's absolutely impossible. So I think we should push back on dispositional orders. We really should, because that's the only way we stop getting partial compliance, because they have a lot. And then you find out that at the review hearing, the client has done 2 out of 3 due to financial difficulty, due to logistic difficulty. They're not getting their kids back in the 6 months allowed. All the most they can get is a contest of some kind of liberalized visits. But the guarantee when they came in was that if they were in full compliance, that they would get their kids back. But we made it worse by not giving them a case plan that is narrowly tailored to make sure that the 6-month period actually makes sense. So it's a promise that we make them, and sometimes we do not remember that. So we did a good lecture on forfeiture, and basically you have to object when the case plan is not adequate. Okay, so it's not, if you don't file object to it or push back and make your record as appropriate, then you may have the issue waived. So do the parents have to sign the case plan? The law says if you sign it, it doesn't mean an admission of guilt. But you don't need to sign it to be bound by it. But it's not uncommon for some judges to order specifically that the client must sign the case plan, or just tell the attorney, have your client sign the case plan. Modification of the case plan. So that is an area also we don't explore enough. Yeah, microphone?
I have a question on the slide for, it's on number 6, the limits on court suspension on non-offending parents. So, my bench officer orders pretty much every non-offending parent into something, even, so I don't understand why I'm submitting to the court's jurisdiction if I know, regardless of what, he's gonna get ordered to do something. So, I don't know what the ramifications are if I just choose not to submit to the court's jurisdiction of my non-offending parent.
Okay, you make your record. If you don't really make a good record, what I mean, I say record here, you have to put your client on.
But I feel like I shouldn't have to. If my client's not offending, I don't know why I would have to, at arraignment, if I choose not to submit to the court's jurisdiction, I don't think the court has any ability to legally order my client into programs.
At arraignments, all the orders are
Or for referrals. Even at, okay, then at this level, if I choose not to submit to the court's jurisdiction, and they're not listed in the petition, I don't understand how they would have jurisdiction over my client in order to do anything.
Then you state your objection so you don't waive the issue and file an appeal.
Okay.
Yeah, so that's the recourse. So there's a case here, basically on point, there where I already discussed CJC in the AE. This is a very sad case, though, because the father was not offended, but he was the one that called the police and mother for physical abuse of the children. But as would normally happen, the father had a change of heart and minimized what happened, felt the physical abuse wasn't there, contrary to his initial description of what happened, testified that the mother wasn't a risk to the children, that he shouldn't have called the police, that he regrets it now. So the court felt, you know what, you're not protected, so we're going to order you into some kind of services. So this is where a client could mess up a non-offending status. So the court ordered him to counseling to address protectiveness. The Court of Appeal felt it was a proper order to make. So this case is also very interesting, in Jasmine C, where mother was ordered into a parenting class following an incident that she really had no fault in, where the father struck the child for starting a relationship. The mother intervened, called the police, did everything right. The court still ordered mother to do a parenting class. The Court of Appeal said no, that notwithstanding parenting will be beneficial, that there's really no basis for that. Mother hasn't done anything wrong for mother to do parenting. So we just have to bear that in mind when we add additional layer of parenting class for our client, thinking that it's not really that much, it's only a week or two, or maybe 4 or 5 weeks. So modification. So you can modify a case plan by filing the proper motion, which usually would be a 3-year. The department can also modify the case plan by filing the same motion. But the department also has an obligation, especially when you come to a scenario where reasonable services are at play, and the department, within the review period, found out that the circumstance of the family had changed. The department is under an obligation to revise the case plan, bring it to the court's attention, and provide the required services. Like if the client, when the dispo was done, was not incarcerated and subsequently became incarcerated, the department usually would try to provide the required services based on the change in the circumstance of this family. So they could do that before coming to court, or they could file a motion for the court to add services that they determine is available in the place of incarceration as an alternative means of compliance, consistent with 361.5 E1 subsection E. So the substance of a case plan. I put this topic here because, and I gave the example already, a case plan that says individual counseling to address case issue. It has to be clearer than that. Either it addresses protectiveness, either it addresses conflict in relationship or impact of conflict between parents on children, or something to guide the client along the line. So I have a few cases here that I think may be helpful. So here the father was ordered to do random testing. The father filed an appeal because the allegation of drug use was basically dismissed. But there were things in the report, statements by father, his admissions, and all that that indicated that he had a drug problem. So that's where the court could glean information from the reports or the circumstances of the family, notwithstanding the allegation was struck, to order the parent to do some kind of services. It's not uncommon for the department to propose, I'm going to dismiss B2 if your client submits to 5 on-demand or random testing, because there's something in the report to anchor that. But if there's none, then you have to be vehemently opposed to that. So in this particular case, the court ordered mother to do a substance abuse program and a testing, because mother believed, and rightfully so, that there was an invention, a scientific invention that had the capacity to generate income, which the court felt was a sign of mental health. But the mother's lawyer was able to establish that such an invention actually exists, and was able to demonstrate that to the court. So the Court of Appeal said basically, that one, the invention was not a figment of mother's imagination, but even at that, there's really nothing to ground the orders that the court made. So in as much as there may be things in the report to suggest to the court the need to order services for the client, but those things or those facts must be compelling. It wouldn't be at the whim of the court, to do that. So we discussed in JP. So there's a particular language that was used in describing in the JP, basically saying that if you're going to order a case plan for a client that has a handicap, like a barrier to compliance, you have to include in that order the means to overcome that barrier. It has to be very specific as to what they need to do. So if they need an interpreter to accompany them to the classes, that's what the court has to order very clearly. The court cannot rely on the department to figure that out. If it requires the client to, whatever the court wants, whatever means to eliminate the barrier, the court has to figure it out. So the court really has to do some thinking, and we also have to do some thinking. And I think all the thinking we need to do would be to identify those barriers based on the conversation with our client and make sure that the court is aware of that. And then we'll leave it up to the court to figure out what to do. Okay, so the example, the Burmese case where because the client doesn't speak that language, that's the barrier. So it's for the court to figure it out. Because the orders will be as to what the department needs to do. Sometimes they have to pay for it. So that's why it's not something that should come from us. It's something that the court will order them to do.
I'm just going to push back on you just a little bit, because I think that we have to come up with ideas too. So say you have a client who's developmentally challenged, okay, and they've got a regional center coordinator. I think that you could ask that the case plan read that, oh, sorry, I have a big enough mouth, I think.
It's for San Diego and Lancaster. They can't hear without the mic.
Oh, okay. I think that we should have a case plan that specifically would say something like parenting, but that the social worker would coordinate with the regional center coordinator in establishing, parenting that provides in-home services or something like that, something very specific. Because if we rely on the bench officers, they're going to come up with something like, no offense to Eric Hockey, but something like that just, she means well, but we know more about our clients and what they need and what they have available to them. And so I think we should try to get as much specificity in the case plan as we can.
Thank you. I think we're on the same page.
Yes, I do. Oh, absolutely.
Microphone.
Sorry, what about the whole bit about the licensed clinical therapist? This is something that I feel like impacts a lot of our clients because they try to go get services at places that offer lesbian parenting and DB, and they also have counseling that works with their schedule. But those people aren't licensed, or they're interns, or they're waitlist, or there's like all these continuous barriers. Is that, and to push back on that at DISPO, what would be an appropriate?
Okay, yeah. So,
Can't you just not get it?
okay, very, very good point. But it requires almost like a revolution in the courthouse. Because the department has that 60-day window. So if they're going to recommend a licensed therapist for the client, the dispositional report has to address the availability of that. So you're going to put the DI on the stand and ask what preliminary inquiries or investigations that she made with respect to availability of a licensed therapist, and which ones is she proposing that the client attend, with a clear list of those agencies to make sure they are available.
Should I? Sorry. Thank you.
Viator, I really want to thank you for doing this MCLE, because I think this is really critical, that we really hone in on what the case plan is. But to me, how do you say it, like the big issue, whether it's a licensed therapist or a 52-week domestic violence program, is who's paying for it, and how can we incorporate our arguments in the case plan, bringing both the court and the department into the reality that our clients will never comply if they can't pay for it, and why is LA County out of whack with every other jurisdiction in California as far as payment goes, and can we envision arguments to be made at DISPO as part of the case plan, really drawing this out. A few minutes ago I had to race into the other room because Dennis was asking me for that new case that's an unpublished opinion that just came out on domestic violence and homelessness. And it's an amazing opinion because the appellate court went on and on and on about the problems of homelessness. And it was like reading some type of social political critique on homelessness. Can we get the appellate court out there talking about poverty and the inability of our clients to afford these programs, and how can you address that in the case plan?
Is that a question for me?
Yeah.
Figure it out.
Because she's retiring, it's up to you.
One thing I've noticed is that the courts do not want to have any contests. And for the most part, the courts do not want a contest at the dispositional hearing. But the only way to address that is to have the client understand with the proposed case plan, and the client will be able to articulate their work schedule, their income, their expenses, and how that leaves them with next to nothing. So that creates a barrier to compliance. So the court will be forced to handle the issue. So the court is now confronted with a barrier. So do you think with all these expenses you have to make and keep life going, do you think you'll be able to afford services that cost $100, $200? No, I have to give up something. So the map would definitely show that this client would not be able to do more than one or anything that is not free. So that way you've created a record. So if the court doesn't address that in formulating the case plan, that will be in violation of JP. Not only will be the case plan unreasonable because it's setting the client up for failure, it's designed to fail, and also a trap, and it's not narrowly tailored. So, but if we do not create that right environment for the Court of Appeal to intervene, then we are not getting there. I have always thought about doing that, but I hope somebody does. Emily?
I just wanted to say that going to that point, this might be one of the few times when stipulated testimony might do the job. If all you're trying to enter into evidence is the cost of the program, your client's income, certain basic facts like that, and you're trying to split the difference between the court's tolerance for you taking up all their time with an extended contest and getting that information and evidence, stipulated testimony might be a middle ground. We were lucky enough to have a case that one of our attorneys got release at detention over the department's objection. It was a similar homelessness type situation, and we were lucky enough to, and it was based on stipulated testimony about the financial barriers that this family faced. We were lucky enough to land in Division 4 when the department took a writ on it, which was the same one that did that great unpublished homelessness case, and the Court of Appeal dismissed the writ. So clearly Division 4 at least is sympathetic to this. I don't know if all of the 2nd District is, but we gotta keep trying.
Yeah.
So the only way to get the reprieve, which continues to plague compliance, would be for the somebody to take it up to the Court of Appeal for them to look at it. So maybe they'll say something that will compel the judges here to factor that in, not only in developing the case plan and make it very narrow the way it should be, but also for the courts to make orders as to exploring payment options. Okay, because what we currently have is low cost, no cost, and it hasn't really worked, and we don't push that, explore that as much as we should, you know. But that is a different topic for the reasonable services scenario. But basically, if your client is not able to do services and finances is a barrier, I think within the review period, you should bring it to the court's attention.
Yeah. Thanks. So you mentioned that low cost, no cost is kind of the threshold. I've been having success getting DCFS to assess all available funds, but really that doesn't make a difference either. Is there something else that's more concrete that we could request?
Currently, no, except somebody takes up that handicap issue, the financial difficulties issue, and then we'll get some guidance from the Court of Appeal. Yeah.
Going back to counseling, I know it doesn't address the question that was posed in terms of the licensed therapist, but I think counseling component is also something we can use offensively, especially with lower domestic violence type of cases. I mean, it's almost like a checkbox, and it's like parenting, DV, counseling, yada yada, anger management, automatic. But what I've realized is a lot of courts are actually sympathetic when you could lay out the issues in terms of the poverty or in terms of full-time working. I know especially with some male bench officers, they're more sympathetic because a lot of times it is gender specific in terms of having to work. So sometimes they'll actually incorporate parenting or DV into the individual counseling component. And that way we can knock out the extra checkbox. And so sometimes you can use that offensively. And then the other thing I would add is, I don't think we're doing it enough, but 211 is really great. It's better to go in person than to call, but it's great. And so I wouldn't overly depend on the social worker unless you have to. I would have them go to 211 that day at the arraignment hearing if possible. And so I think we can make a good record, but for practical purposes, there's a lot we can do off the record too that can help this. But it's true, I think we're dealing with an indigent population, and we have to be able to not only win on appeal, but at the trial level we have to win too. And I think there's alternatives to just winning on appeal as a practical matter. And so hopefully that helps some of us, because I know we'll take every inch that we can get.
Thank you very much.
You have 1 minute.
No pressure.
Commissioner Gibson in 426 is a former DA, which cuts both ways, but it results in when there's a request for a 52-week domestic violence program and anger management, he flat out refuses and says a 52-week domestic violence program includes anger management. So we need maybe to get that documented somewhere and hand it out to every bench officer on every case plan that requests that.
Any other questions? Okay. So just to round up, we have to ensure that whatever case plan that we agree to, because the client will defer to us, is one that when we come back in 6 months, the client would be in substantial compliance with that case plan. If we have to tweak individual counseling to pad it with goals, to dispense with all other services like domestic violence, anger management, individual counseling to address all of those, I think we should. And also, we have to look at the reports to see whether the department did any kind of preliminary research to see whether services are available. We don't want our clients on the wait list. That really undermines the verification process. So, if there's any other questions, if not,
Thank you. And